So good afternoon, good morning, good evening to everybody, depending on where you're dialing in from. Thank you for taking the time to join us today to discuss the mystifying topic of tribunal secretaries, which we hope to demystify a little bit for you today. Um, Before I start, thank you to the IAMC and Singapore Very Young Arbitration Practitioners for co-hosting this webinar. We have a great lineup of panelists today, who in my opinion are some of the best people to speak about um, anything that relates to this topic really. So I will quickly introduce our speakers. I'll do it quickly because we're really more interested in knowing what they have to say, and everybody I think kind of knows who they are. So our first speaker is Dr. Ole Jensen, who practices international arbitration at WilmerHale in Berlin and London. He's represented clients, assisted tribunals and arbitrations conducted under most rules, including ICC, LCIA, DIS, SEC, etc. Ole is also engaged in academia. He is the author of Tribunal Secretaries in International Arbitration, which is not at all relevant to what we are speaking about today. He holds academic visiting positions at the universities in Europe, Latin America, and is an assistant editor for the Journal of International Arbitration. We also have Juan, Camilo, uh, Jiménez-Valencia. I
That was
made sure that
perfect.
I got the pronunciation correct. Juan Camilo is Colombian qualified. He obtained his LLM from in international dispute settlement from the Graduate Institute of International and Development Studies and the University of Geneva. He is a senior associate at Hanotiau and Berg, where he acts as tribunal secretary and assistant to the tribunal for Professor Bernard Hanotiau in complex international commercial and investment arbitrations, both ad hoc and under a variety of rules, ICC, SIAC, ICSED, LCIA, etc., etc. Here also spanning various industries. Juan Camilo co-founded Colombian Very Young Arbitration Practitioners and Latin American Arbitration Practitioners EU. Simona, we also have Simona Valkova. Simona is an independent tribunal secretary. She assists tribunals in international commercial and investment arbitrations under most arbitration rules, LCIA, SEC, SIAC, HKIAC, etc. Prior to that, she worked as a full-time arbitral assistant to Professor Julien Liu, KC, providing legal assistance on many of his cases, as well as assisting in research and drafting of many academic papers. Simona is also a teaching fellow in international commercial and investment arbitration law at the School of International Arbitration, Queen Mary University in London. She holds an LLB in international and European law from the Hague University and an LLM from LSE. And last but not the least, we have Sunita Advani. Sunita is an arbitral assistant and tribunal secretary to Mr. Michael Lee, an English arbitrator member of 20 Essex in Singapore. She assists Mr. Lee in his high value and multi-jurisdictional commercial arbitrations across a variety of industries and which are administered by leading arbitral institutions such as ICC, LCIA, SIAC, HKIAC. Sunita achieved a distinction grade in HKIAC's world-class tribunal secretary training program. We will discuss these a little bit further during the webinar, and has been listed in HKIAC's Tribunal Secretary Training Program website and a KICAS Tribunal Secretary panel. Prior to this, Sunita was a junior associate in a leading international firm in Singapore and has worked as a research assistant at the Columbia Center on Sustainable Investment at Columbia Law School in New York. Now that we've introduced our stellar panel, a few things before we start. We would love to hear audience questions, which we will try our best to answer in the last 15 minutes. You can post your questions in the Q&A function on Zoom at any point in time during the webinar, but we will deal with them at the end. We're also going to be running a few audience polls during the webinar to make this as interactive as possible. Unfortunately, we can't have you all speak, but we'd like to hear what you have to say via these polls. You will see the poll question coming up, and also voting buttons. So can you please cast your cast your vote once you see the poll. So without further ado, let me start by posing my first question to Sunita. Sunita, what are the typical tasks of a tribunal secretary? It's pretty low ball question so that we can, get into it.
Thank you, Shanelle, and thank you everyone for joining us today. And on behalf of the Singapore chapter of Very Young Arbitration Practitioners, thank you as well to the IAMC Hyderabad for being an excellent co-organizer of this event. So to answer your question, the typical tasks of a tribunal secretary include writing parts of awards, factual parts of awards in particular, such as the summary of arguments and procedural history, as well as assisting with procedural orders, document production rulings, specifically under the supervision of the tribunal. Tribunal secretaries also assist with correspondence between tribunal members, as well as between the tribunal and the parties, deal with matters relating to invoices, organize meetings and hearings, attend these and take minutes of these, as well as observe deliberations. Tribunal secretaries do not take on any decision-making functions of the tribunal.
Thank you, Sunita. And this is exactly where we're going to go into our first poll. So the audience can, start off and hit the ground running. So you will be able to see the question on your screen. The question is, you are participating in deliberations after the merits hearing. One of the arbitrators misremembers or misstates a particular fact or evidence. Can you correct them? The only two answers, yes or no. It would be great if the audience can cast their poll. Okay, so 77% say yes and 23% say no. I'm going to ask Simona what she thinks about these audience answers.
It's actually very interesting to see that 77% of the people think that you should correct the arbitrator. And I think the idea of this question is, and we phrase it particularly to ask during deliberations, because it really matters when that's done and how it's done. Because in principle, you're not supposed to intervene during deliberations. So you're not supposed to correct the arbitrators, even if you think they're saying something wrong or you disagree with their analysis of the facts or understanding of the facts or whatever it is that they're discussing, because it's not your place to say, right? Because it could be interpreted as you influencing the decision-making process in one way or another. But on the other hand, as Sunita already explained, one of the tasks of a tribunal secretary is to manage the whole case file, summarize the parties' positions, which includes review of the evidence and witness statements. So if the arbitrator misremembers or misstates a particular fact in terms of date or, I don't know, witness's name or relationship, basically something that's not contentious and does not relate to a contentious issue in a case that requires a decision to be made to it, then some could argue that yes, you should flag it. But it really depends on the circumstances of the case, on your relationship with the tribunal, how long you've worked with them on this case or on other cases. Also the extent of your duties as agreed with them and the parties to what is it that you cannot do or can do. So you should be very careful in how you execute this, so to say.
That's interesting advice. So bottom line is read the room and know if this is if your intervention is welcome, I guess. No, thank you very much, Simona. Let me move on to Juan Camilo, who I'm going to ask you a question that kind of flows from Sunita's background of what are the typical tasks of a tribunal secretary. Why do arbitrators appoint tribunal secretaries, in your opinion?
Thank you, Shanelle. Just to start with, I would like to say also thank you to Singapore Very Young Arbitration Practitioners and the IAMC Center of Hyderabad for this invitation, and especially to Sunita for this lovely invitation. To answer your question, I think this may very well depend on the arbitrator, the relationship between the arbitrator and the tribunal secretary, the specific case, and the tasks that will be undertaken by the tribunal secretary in the proceeding. My general answer would be a tribunal secretary is appointed to decrease costs in handling the arbitration and to increase the quality and/or speediness of decisions. I would say that one specific reason could be simply to handle technology, case management software, cybersecurity issues. Another could be just to have a separate pair of eyes, looking at every submission, reading fast to see if there was an application that needed to be handled and flag this to the tribunal if this is the case, or simply, and in some cases, because it would be impossible for the tribunal to do their job properly without a tribunal secretary. And I would like you to picture this scenario, because in my mind, international arbitration and international dispute settlement has become a very sophisticated and voluminous animal. Imagine that you have a massive case with one small army of lawyers on each side. You have 20 lawyers for claimant, 20 lawyers for respondent, millions of, or let's not exaggerate, but hundreds of exhibits and dozens of applications being made. It would be simply impossible for the president or the tribunal even to handle all of this as fast as the parties wanted to be handled without any assistance. So basically, I would say that those are the reasons why to appoint a tribunal secretary.
So again, bottom line is it's just a matter of efficiency for the tribunal. Let's try and see what the makeup of our audience is, before we move on to the next questions. We're going to put up the next poll. We want to know, have you worked for an arbitrator in one or more matters? So have you acted as tribunal secretary, or not even tribunal secretary, even unofficially, have you worked for an arbitrator before? Okay, so 45% people have worked for an arbitrator and 55% have not. All right, and then I'm going to ask one more question to know a little bit more about our audience. Have you formally ever been appointed as a tribunal secretary? So that was more an informal question. 26% have. Okay. In which case, it seems like half our audience has worked, a little less than half our audience has worked for an arbitrator in some capacity, and 26% have done so formally. Let's now pose a situational question and see, what your thoughts are. That's the next poll that's going to come up on your screen. So as you can see, the question says, you have drafted several awards for an arbitrator during an internship and want to advertise this experience on your CV. How detailed can you be? And there are 4 options. 1, you can only note that you have assisted the arbitrator. 2, you work with Dr. Y on her arbitration cases. 3, drafted award for Dr. Y. Or 4, drafted awards for Dr. Y in ICC case number 12345, SEAC case number so and so, an ad hoc arbitration between ABC Limited and DEF SE. How would you describe your work on a CV? Okay, so 55% say only note that you have assisted an arbitrator. 37% say work with Dr. Y on her arbitrator cases. 3% say drafted awards for Dr. Y, and 5% say drafted awards and specified the case names. Ola, I'm going to go on to you, given you've written a whole book on this. What do you think? What do you think of these answers?
I can say that actually it's the ideal answer almost that I have been hoping for, because I think with a slight variation in number 3 and 4, this is how I would see it as well. But maybe first one step back, also taking the other 2 polls before, we have seen that only in the least amount of cases do people who have worked as a secretary or assisted an arbitrator in some way have been formally appointed as such. And that is quite interesting, because if you look at the rules that we have today, and we'll talk about them a little bit more in a moment, you will see that they all say that if you appoint a tribunal secretary, that needs to be done formally. So you will have to involve the parties, send them the tribunal secretary's CV, and get their agreement. That's how it's typically done. And then, of course, and that's why we picked the situation of an internship, that is not always feasible. If an arbitration runs for 2, 3, 4 years, and you're in an internship capacity only with a law firm or an arbitrator for a shorter amount of time, typically you wouldn't be able to be appointed as tribunal secretary. Nevertheless, we all know that people still work on arbitrator files, and they do all kinds of stuff. And in our situational question that we just looked at, we had a maybe rather extreme example that an intern had drafted 3 awards in total for an arbitrator. And the obvious competing interests here are, one, that someone who has done that work and who has, contributed meaningfully to an actual arbitration case wants to advertise that experience. Of course, you want to show somehow on your CV that you've worked with an arbitrator. If it's a famous one, maybe ideally even identify that individual. And if it's drafting, you might want to say it's been drafted, right? But the other competing interest, obviously, is your professional responsibilities that you have. And even as an intern, you very much, of course, are under confidentiality obligations, both vis-a-vis your law firm, the arbitrator, but also more generally in the role of a secretary to the tribunal, you would be under confidentiality obligations. So I agree very much with our audience that it's very difficult to divulge party names, for instance. That was the 4th answer that we saw in the poll. I would also consider it difficult to divulge publicly in a CV, and we all have to be clear that a CV can make the rounds and be sent on, maybe without you knowing, that you have drafted awards for a specific arbitrator, right? Because if I'm in a case and that arbitrator is handling the case and they have not appointed a secretary, maybe I start to wonder, who has been involved behind the scenes that I don't know of, and what does drafting exactly mean, right? So, that goes back to something Simona said. As a tribunal secretary, I think one of your main skills and features should be that you're humble, that you know your place. And that goes also to how you then advertise your experience. And I think it's better to err on the side of caution. You can certainly, ask the arbitrator you've worked for, is it fine if I identify you on my CV, just saying I've worked for you? But if that's not the case, maybe you just say you've worked for a arbitrator, and then you can maybe discuss informally in an interview scenario what you've done more specifically.
Thank you. That's actually possibly one of the best pieces of advice that I've heard. You should be humble when you're describing your experience. That's the second best piece of advice that I've heard Ola give me in my experience with him. I won't tell you what the first one is, but just following on to what you just said, what is the regulation and case law on tribunal secretaries? Ola, if you could just maybe elaborate on that a little bit for the audience.
Yeah, I'll keep it short because that's essentially a whole webinar in itself, or a 90-minute lecture, or whatever you want it to be. The short version is that today you will find the tribunal secretary at least being mentioned in a whole number of national arbitration laws, in most of the main institutional arbitration rules, and in many soft law guidelines, be they institutional as well. For instance, the ICC, of course, has its main arbitration rules, and then there's also the ICC note to parties and other tribunals. And in that you will find quite specific rules on what the ICC thinks a tribunal secretary should do, but also should not do. So the one thing that is often regulated, particularly by institutions, is the permissible scope of tasks of a secretary. Sunita went through them. It will also often say that you're not allowed to delegate decision-making as an arbitrator. I mean, that's very clear, I think, to everyone. An arbitrator is appointed for their specific qualities. And if they were allowed to just pawn it all off to some assistant, that is not something the parties or the institution who appointed them would expect and should expect. And then, you have rather granular ideas, sometimes diverging ideas from different institutions what secretaries should do. The other thing that is regulated and more specifically as well in national arbitration laws is that a tribunal secretary needs to be impartial and independent and can indeed be challenged in theory. That's something I think we will address in a bit more detail later on. And then sometimes they also talk about confidentiality and about remuneration. So that's the main topics that we will find in contemporary regulation. Interestingly, it wasn't like that if you go back some 10 years ago. Maybe 2012, 2013, you hardly had anything on secretaries. Most of it was done informally. And that is what also, I believe, sparked a number of cases where parties tried to challenge arbitrators or, in fact, awards for their alleged misuse of tribunal secretaries. And they're all rather similar. The argument always goes, well, we appointed a sole arbitrator, and now in a Swiss case, that's now an example from the Swiss case, the sole arbitrator appointed a legal advisor because the arbitrator was an architect, not a lawyer. And he appointed a tribunal secretary. And so the party said, well, ultimately, sitting in the hearing and seeing those three individuals pose questions to us, we were before a three-member tribunal, not a sole arbitrator, and now we can challenge the award for an improper constitution of the tribunal. The Swiss Federal Tribunal back in 2015 was not convinced, dismissed the challenge, said again what we already heard, no delegation of decision-making, but you can still seek assistance. And all of the court cases that we've seen go rather far, I would say, what is allowed, what a tribunal secretary can do. Similar example before the English High Court, a few years later, there was not a challenge to the award, but to the entire tribunal. It was a procedural application related to document production that the tribunal president wanted to forward to the tribunal secretary, asking for the secretary's views, just saying, what is your take on this application? But instead of forwarding it to the secretary, the president replied back to the party making the application. So the party saw how the president communicates internally with the secretary. And they said, well, obviously, the president was delegating decision-making, albeit on a procedural matter. He's not impartial and independent anymore. And by the way, neither are the co-arbitrators because they didn't police the president appropriately. Again, this was dismissed both by the LCAA in the original challenge decision and ultimately by the English High Court for different reasons that I explained in relation to the Swiss case, mainly that there was not enough evidence to suggest actual delegation of decision-making. And the High Court confirmed that ideally, the tribunal would consult within its members, but there could be instances where you also ask a secretary for their opinion without this meaning that you have, relinquished your decision-making power. And then finally, a Dutch and a Belgian case. The Belgian one is the most recent one. And the Dutch case is the famous UCOS case that I think most people will have heard about. This is also where the topic of tribunal secretaries came to everyone's immediate attention back in 2014, because the Russian Federation challenged the UCOS awards, which were worth more than $50 billion based on many reasons. One of them being that they thought the tribunal's assistant had charged too many hours, he had charged more than each arbitrator had charged. And this meant that he must have had a meaningful role in the arbitration that went beyond the typical tribunal secretary tasks. And then Russia went so far as getting an expert in linguistic forensics who would look at the award and apparently said she was able to determine that based on how the sentences were structured and which words were used, it was extremely likely that the assistant had drafted certain parts of the award. That did not convince the Dutch courts. They also denied that challenge to the award, that particular ground, saying that, if you have a three-member tribunal, it's almost impossible to say who drafted what, because the whole purpose of an award is that it's a communal joint product. And so to say, it's been drafted by someone specific is a bit difficult. And otherwise, again, the Dutch courts confirmed a broad scope of tasks for the secretary. I can briefly mention the Belgian case just because it came out this year, a couple of months ago. The interesting thing here was that it concerned this ICC note that I've mentioned. So the court actually looked at the soft law guideline published by the ICC. A party had argued that the secretary had done more than what the ICC expected, and the court ultimately denied that as well.
Thank you, Ole. Before I move on, I see only one question in the Q&A tab. So, this is a shout out to the audience. Please ask us more questions. So we've discussed what a tribunal secretary does, how they're regulated, etc. We'll move on a little bit to, how do you become one, and what you can do to prepare yourself for one. So let me pose this to Simona. How can a junior lawyer effectively prepare for tribunal secretary work? What do they need to do?
Well, for starters, I think that everyone who wants to be a tribunal secretary should first read Ole's book on tribunal secretaries, because it explains in a very comprehensive yet structured way what this role is all about. And you should approach it as you would approach any other legal role that you're going to apply for or you have applied for. First, do your research and really understand what is it that you're going to be asked to perform, what are the limits of the tasks or the services that you might be asked to provide, the different rules and guidelines that you apply to you, as they were already mentioned by Ole, because you need to know and be aware of all of this before you even apply for the job, so you can show that you know what it takes and you can do it. And then the second thing you need to identify for yourself is in what capacity you want to act, or rather, how do you want to act as a tribunal secretary? Is it something that you want to do full-time, or is it something that you want to do alongside another job that you're doing? For instance, if you want to be a full-time arbitral assistant or tribunal secretary, then you could either do it by working for yourself, being independent, or you can do it by working at arbitration chambers, providing support to different arbitrators. You could even work full-time for just one arbitrator, as long as his or her work justifies hiring you full-time. And then if you want to do it on the side of something else, you could be an associate in a law firm and then act as a tribunal secretary in one or two cases, as long as one of the partners are arbitrators. Or you could even work in an institution as a counsel and then provide tribunal secretary assistance, because I know some institutions allow for this. So you need to be very clear what this is about and how you want to do it. And then once you know this, you can go and see how your background and level of experience fit into it, or if they don't, how you can get there. Because the good thing about being a tribunal secretary is that there are no hard rules on what kind of experience or the level of experience that one must absolutely possess in order to be a tribunal secretary. So there are cases in which, and that's because obviously it depends on the case, and it depends on what is it that the tribunal is looking for in terms of support from the tribunal secretary. So there are cases in which having 2 years of associate experience in a law firm during arbitration obviously might suffice. But there are other cases in which if it's a very complex and big case, or if it's very technical, they might require you to have a specialist knowledge in terms of construction or energy disputes. They might require you to speak certain languages. If the case is conducted in 2 languages, then you obviously have to summarize the parties' positions, which are again delivered in 2 languages. So it really varies, which is great because it's in theory open to everyone, as long as you show that you have arbitration experience and you know what it takes to do the job. But if I am to give one advice that I think everyone should focus on mastering the skill, I would say excellent project management and organizational skills. And I know it probably sounds very basic, and it's one of those things that we all put on our CVs, that we're excellent at time management and multitasking, and we're great with keeping deadlines. And perhaps we are, but when it comes to the tribunal secretary job, I think what a lot of people don't understand, don't realize, or at least I didn't realize myself before I started doing this job, is that time management is key, mostly because you're alone. So you don't work in teams. You don't have anyone that could step in and cover for you if you cannot attend a certain meeting or a procedural hearing. You cannot delegate your functions to anyone else. You cannot have anyone doing your summaries for you, because that's your job and that's what you're there for, to support the tribunal. Equally, you wouldn't have the tribunal helping you, because then the roles are reversed, right? That's not the point of the tribunal secretary. So it's really very important that you know how to manage your own time, and especially if you work for different people and on different cases, procedural timetables are fixed according to the availability of the parties and the tribunal, not your own availability. So if there is a clash between the cases you're working on, then it's it's really bad for you, basically. So master this. As long as you have that, the rest would come. The rest is something that you can learn in the process, or you've already developed from your previous experiences.
That's very useful and practical advice, I'd say. Sunita, I don't know if you want to add something to this, and then maybe you could elaborate on, if there are any training programs for tribunal secretaries. We know based on the introduction I gave that you have done one such training program, but maybe if you elaborate a little bit on what Simona just said and explain the various training programs available for younger practitioners.
Yeah, so I think first I'll start by saying that I agree with Simona in terms of the preparation that you can do and that you need to do in order to take on tribunal secretary work. And I think I'll just add to sort of the skills that she mentioned that you should have in terms of, being in the best place to do tribunal secretary work. So the first would be you should be diligent. You should also be intelligent. You should have good academic qualifications. You should also be willing to take direction, because tribunal secretaries only work under the supervision and direction of the tribunal. And I think this also feeds into Ol's point earlier about being humble and, knowing your place as well. And you should also be just generally helpful. I think it's also important to bear in mind what Ol terms in his seminal text, Tribunal Secretaries and International Arbitration, what he calls the human factor. And so arbitrators frequently appoint candidates that they know personally, who they are confident and comfortable working with, and who they trust. So the range of tasks that can be delegated to a tribunal secretary to a large degree depends on how the tribunal secretary fulfills these tasks and what she does when she runs into difficulties. So the likelihood that there is a sufficient amount of conference between the arbitrator and the tribunal secretary is maximized if there is a relationship of trust. So the other important thing to mention is tribunal secretary training programs. So for the new tribunal secretary, it is valuable to participate in tribunal secretary training courses and seminars offered by the various arbitral institutions. The HKIAC runs a 2.5-day tribunal secretary training program on a periodic basis. And as Shanelle mentioned earlier, I participated in that program specifically last year. I'm also aware that the SIAC ran a virtual tribunal secretary training course as part of the SIAC Academy in October 2022. So a tribunal secretary training program like the HKIAC's is useful for those who do not have prior experience in tribunal secretary work, and it will bring you up to speed on how to perform tribunal secretary work well and how to meet arbitrators' general expectations. But if you've already been working full-time as a tribunal secretary for 2 to 3 years, then a tribunal secretary training program is of limited use, because you can learn, and you would have already learned, how to carry out tribunal secretary work effectively on the job.
Thank you, Sunita. But, just following on to that, you've obviously worked previously as an associate in a law firm, and now you act as tribunal secretary. Was there anything, or is there anything that you know now that you did not know when you were previously an associate about acting as a tribunal secretary?
That's a really great question. So I think first I've learned more about the tribunal's perspective. In particular, I've developed an understanding of what the tribunal is looking for in pleadings, in witness statements, and in advocacy, including in cross-examinations. Second, I have a better understanding of what drafting and advocacy styles work with arbitrators and which ones don't, and with which arbitrators. Third, I've also understood the different working styles, backgrounds, and expectations that the different arbitrators have, and that has an impact on how counsel should represent his or her client. And I think fourth, I've also gained extensive one-to-one experience working with a prominent arbitrator in a way that junior associates might not get to have with a highly regarded partner at a firm.
Thank you. Juan, I don't know if you want to add a little bit to that, because you're obviously also, working in a firm, but you also work as a tribunal secretary. Is there something that you'd like to add to what Sunita just said, and then I can move on to?
Well, I'm going to try to say something quite short without repeating, because Sunita's answer was very comprehensive. I think it summarizes in a different perspective. It's the same job from a different angle, and that gives you a lot of insight as to why decisions are taken. In essence, if I have to summarize it in a joyful way, I would say you learn who wins and why. You learn what arbitrators find persuasive, useful, or annoying, what kind of strategies and techniques works and which do not. I'm not sure if you guys remember, there was a fantastic movie, The Devil's Advocate, in the 90s, in which Keanu Reeves interprets a lawyer named Kevin Lomax. And this was a big shot lawyer, and the reason that he was such a fantastic litigator was because he spent several amount of years in the bathroom of the courts, which had a small hole into the deliberation room of the jury, just listening and listening and listening to what was being discussed in deliberations. And I think having had the opportunity to be present in many deliberations gives you this insight.
Thank you. That's super useful. Ole, can tribunal secretary work be a profession in itself? So can you be a career tribunal secretary, or do you think that that's not a possibility?
So I think that actually very much depends on the term profession. So what you understand profession to mean, right? If profession means you practice exclusively as a tribunal secretary, and that is how you earn your money, absolutely, 100%. And we know many people, including some here, but many others, who do that very successfully. And for the reasons that Sunita and Juan mentioned, it's also extremely valuable, I would say. You get all of these insights, you get your bathroom glimpse into the deliberation room, you get everything that equips you to be either a good arbitrator or a good counsel or both, and that is extremely valuable. If you talk more about career secretaries or profession in the sense that this is something you start and do for the rest of your days until retirement, I'm more skeptical. Just because traditionally and for good reasons, the secretary role has been something that people at the beginning of their career would do, right? There are many examples of now very successful arbitrators who've worked as secretary for 6, 7, 8, 9, 10 years, but they didn't stay secretaries, obviously, for the obvious reason that they outgrew the role and became too senior. Now, I think the tricky part is that is not automatic. Only because you've worked on many cases as a secretary doesn't mean that all of these arbitrator appointments will start flowing in at some point. You can just immediately transition from one role to the other, but rather it takes something else. And that something else could be to also develop a counsel practice. It could be to do speaking engagements like the present one, publishing things, but you will probably need to show that you're ready for the role of arbitrator. And even if you are, then the first appointments typically don't come in swaths, but they will be far in between in the beginning. So that would be my answer. I think it's an excellent thing to do. I think it's an excellent thing to do for a number of years and also exclusively. But it's probably important to always keep an eye on what's next, in that sense.
Thank you. I'm going to now ask a more practical question, because we all obviously know that there are rules that kind of govern tribunal secretaries. There are obligations that that you have. Juan, Camilo, do you know if or in your experience, have tribunal secretaries been challenged? Can they be challenged? Is that something that's open to a party to do?
Well, I'm trained as a lawyer, so I'm kind of set up to answer everything as it depends. So
That is always the
just
correct answer. Always.
you cannot miss it answering like this. I guess you will need to see what the lex arbitri say. You will need to take a look also at the arbitration rules. And in my view, unless there is a strict rule restricting this, I would say that it is possible always to challenge tribunal secretaries. I have taken a look at some of the arbitration laws. I only managed to find 3 in which tribunal secretaries can be challenged. One of it, it's my home country, Colombia. It is also possible in Switzerland and in the Netherlands. If you take a look at some arbitration rules, the 2020 LCIA arbitration rules and the 2023 Stockholm Chamber of Commerce also expressly say that parties may challenge a tribunal secretary for the same reasons that they can challenge an arbitrator on the same grounds. And many other rules do not say this expressly, but in rules and/or guidelines, they say that the tribunal secretary needs to be independent and impartial. And in my view, if you have the right to have an independent and impartial tribunal secretary, then you have the right to enforce this right and challenge a tribunal secretary when you believe that he or she is not independent and/or impartial. In any event, I think that this is at the end ultimately more of an academic discussion. I believe that in general, if a party mentions that it is in some sort of discomfort with the tribunal secretary, either the tribunal secretary will resign on its own, or the tribunal and/or president will tell him or her to please step down. So I honestly don't think that there are many cases in which a tribunal secretary is challenged and there's actually a decision on this.
Oh, thank you. Ola, I don't know if you want to add something to that, but maybe you can, and then maybe you can explain to the audience, assuming you aren't challenged and you are independent and impartial, how you get remunerated for your work as a tribunal secretary. What types of arrangements can be agreed by a tribunal secretary with the tribunal.
Yeah, on the first question, I can say that I think Juan put it perfectly well, and I entirely agree. I'm also not aware of any published challenge decision to a secretary, very likely just because that is usually being dealt with informally, mostly also at the beginning of the case, right? Because this is when the parties will see the secretary's CV, will see their maybe qualified statement of impartiality and independence. And then if they feel uncomfortable, as Juan said, someone else is appointed, no one is appointed, whatever makes most sense in the circumstances. On remuneration, and I see this was also one of the questions in the Q&A. So maybe two different topics, so to speak. The first is who pays, right? Is it the parties or the arbitrator? And the second question is, how does the tribunal secretary get their money and how much? So first turning to the first topic, who pays very much depends on how the arbitrators are paid in most cases. So we all know that under some institutional rules, including the LCAA, the SIAC, SIAC mainly have remuneration by an hourly rate for the arbitrators. And under other institutional rules, ICC and many others, it's ad valorem. The arbitrators receive a lump sum based on the amount in dispute. If they get an hourly rate, then of course the parties can save money, and it also goes back to what Juan said about the purpose of a tribunal secretary being to reduce costs. So if a secretary can be appointed to do correspondence, to help with drafting procedural orders and things like that, these are hours that the arbitrator will not have to spend at, let's say, £800 per hour, and instead the secretary can do it at £100 per hour, for instance. So this is supposed to be an immediate cost-saving factor by having someone more junior with a lower hourly rate do tasks that the tribunal doesn't necessarily have to do itself. In ad valorem cases, the idea is that the secretary is more or less priced into the lump sum that the tribunal gets, right? So the tribunal gets, or the arbitrators get, a certain amount of money, and if they want someone to assist them, the ICC and many other institutions say, well, then they have to pay the secretary themselves. These are the main two schemes of who pays. And then how is it done? Again, very much depends on the particular setup. Essentially, we have secretaries working at an arbitrator's law firm, and then their secretary work is just one of the tasks they do, or maybe even the main tasks of working as an associate or whatever position at that law firm. Then they just get their salary, right? They don't get typically don't get a particular remuneration for tribunal secretary work. If they work in an institution, it's the same thing. We know that the PCA, ICSID, and some other institutions appoint secretaries from their staff to the tribunal. And they, of course, also get the typical institutional salary that they would otherwise get. Now it gets more interesting if we talk about what I would call external secretaries, so someone who does it independently, who's not employed by the arbitrator, but maybe even works with several arbitrators, as we will discuss. And in that case, it's very much up to the arbitrator and the secretary to discuss how it should be done. Just some examples that I've seen is that the secretary gets an hourly rate, even if it's an ad valorem case, then the arbitrator says, well, you note down the time that you spent on the case and I will pay you per hour. Another option would be to say you get a pre-agreed lump sum, or that lump sum might just be a fee, a part of the fee that the arbitrator gets. So the arbitrator would say, you assist me in the case and you get 10%, 15%, I don't know, of whatever fees I get. So these are some ideas of how it could be structured. In terms of the exact money that you get, what the fees are, I've looked at it. Obviously not a lot of it is publicly available, but I've looked at it a couple of years ago, and the range seems rather broad, right? So you see, back then I saw anything from 50, 75 euros per hour to, I believe, something like 300 or 400 euros per hour for a big case like the UCOS case. And that makes sense too, because we've discussed that secretaries often are junior, at least some of them at the beginning of their careers, and then of course the hourly rate would be lower. The assistant in the UCOS case was ultimately a partner when the case concluded, because it took 10 years to get through, and so also there it made sense for him to have a bit of a higher hourly rate. But again, it very much depends, and it's something in ad hoc arbitrations for the parties to agree to, otherwise for the secretary and the arbitrator to discuss.
Thank you. I'm going to move to Simona in a second, but Ole, just I'm going to slip in an audience question here. The first one, which kind of somewhat relates to remuneration to an extent, but the anonymous attendee asks, how easy is it to work as tribunal secretary while working as an associate? That is, how do firms see it in terms of finances? It might not bring the same money as a client, and how does it work with conflict of interest? It's kind of related, but I think you might be best placed to answer this question.
So I would say the short answer is it's fairly easy if there are arbitrators at the law firm, obviously, right? So if there are arbitrators, there's typically, as we've discussed, a need for assistance, and then the main and obvious person to go to is the associate. So it is possible and also very common for tribunal secretaries or for associates working at law firms to be appointed as tribunal secretary by one of the more senior lawyers at the firm. It can also make sense in terms of finance, I would say. As I said, if it's a hourly a case paid by the hour, then while it's less money, the secretary is available to charge their fee to the parties, and the arbitrator, if they're busy, can charge their higher hourly rate at a different case, right? And then overall, financially, it may make sense to get more junior people on and for them to do the work both in per hour and ad valorem cases. But I think there's another consideration that not necessarily exclusively relates to finances, and that is what Sunita and Juan discussed, which is the learning experience, right? So obviously, as a law firm, you want your associates to grow as lawyers and to get this, in my opinion, very valuable experience. And so I don't think it's an exclusive number game. You also look at, what is it valuable for the associate? Do they learn? And that's, I think, one of the main considerations, actually. I mean, that's of course a consideration. It always is. I don't think it will happen too often that you will be unable to work as counsel in a case because you've been secretary, in a concurrent matter or something like that. That will typically get blocked out by the arbitrator, right? Because your conflicts of interest will typically be very similar to that of the arbitrator that you work for. So I don't think that is a huge consideration.
Thank you. So I guess in terms of money for the firm that you work for, it's not always about tangible, but it's also about the intangible benefit to the associates. Simona, I had a last question for you, which I'm going to club with two audience questions. So my last question for you was, can you work for multiple arbitrators as a tribunal secretary? But I'm going to club it with two questions from the audience. One is, how do you find an opportunity to work as a tribunal secretary? Is it all informal via contacts? And another audience member has asked, where can one find part-time opportunities, as Simona was mentioning? So I guess if you can maybe elaborate on, can you work for multiple arbitrators as a tribunal secretary, and how does one go about finding these opportunities if maybe you're not in a firm?
Okay, so the short answer is that yes, you can work for multiple arbitrators, and I think I'm only going to focus on from the perspective of being independent, because the others are pretty straightforward when you work in an institution and you support different arbitrators, or when you work in arbitration chambers and you support different arbitrators, because there is structure in place which more or less helps you regulate how to do that. But when you're independent, essentially, you have to take care of that yourself. So it is possible, but I would suggest you only do that once you've gained substantial experience working as a tribunal secretary in any way, because you need to understand the nature of the work and you need to understand how long it takes to do certain tasks, how long it takes to work on certain cases. You need to be familiar with a lot of arbitrators because everyone has a different method of working and they want things to be done in a certain way. So just because you've worked, I don't know, full-time for one person for 3 years, yes, of course, you've learned a lot. But the moment you start working with different people, you see that they do things differently. And that takes time to adjust. So you don't want to just throw yourself in the sea and then accept as many work as possible. Be very selective and take it step by step to make sure that you don't overpromise and underdeliver. So once you're familiar with that and you feel more comfortable working on cases, you need to consider that you're the one responsible for your own conflict of interests, because unlike a law firm, the arbitrators that you work for do not talk to each other. They do their own conflicts of checks, and then you have to do your own, which includes the current arbitrators you work for, but also your previous experience. So if you worked in a law firm and in that law firm you worked on cases, either as an associate or a tribunal secretary, that counts too. And that's something you need to first disclose to the arbitrators, and then they disclose to the parties when they propose you for appointment. So it's a lot of issues that you need to think about. It's not handled by anyone else. And you need to be really familiar with the job to do it properly so that you don't get challenged later on. Aside from that, another thing that I wanted to add on the remuneration point, which all the very comprehensively covered, is that if you work independently, and then obviously depending on the relationship, if you get paid by the parties or by the tribunal, in any event, most of the time you do not have a secured certain income coming at the end of the month. So you don't have a salary per se. So that's something you need to consider, because often tribunal secretaries get paid as when the arbitrators get paid, and that's not every month. Sometimes it's after a certain milestone was achieved, like a partial word was issued or a procedural decision. Other times it's at the end of the case. So you need to make sure that you have enough work so you can sustain yourself. But at the same time, as I said, you don't overburden yourself, and you still are able, and you're still physically capable of working on all fronts. when it comes to finding this type of job, I think it's very difficult to explain because there is no straightforward application process. If you're not in a law firm, if you're not in an institution, and if you're not in arbitration chambers and you try to get a job on your own, what you could do is you could either write directly to the arbitrators you're interested in working for, and you know that they work with tribunal secretaries or with assistants, because if they don't, then it's pointless to approach them. So first do your research and see who is working with assistants and then tribunal secretaries, and then see if your experiences more or less your experience can relate to the work that they're doing, so they can see value in hiring you and assisting their cases, and then approach them directly. Another way would be, I know that sometimes people who act as research assistants for their professors, or even not even their professors, but just do research assistant jobs, if the person that they're working for also acts as an arbitrator, they might invite them to be their tribunal secretary or arbitral assistant, because they would have gained their trust, they would have shown that they've got the skills and the understanding to do the job. So that would be a more of a natural movement. And then I guess I haven't done a tribunal secretary training course, but I've heard that it's very helpful in terms of making contacts and then showing that you have some sort of credibility and training when you apply for this position. So those are the few options that one could explore when looking to get this kind of to get into this kind of job.
Thank you. I see that Surabhi Ahuja has asked, are there any disclosures to be made by a tribunal secretary? Sunita, I wonder if you want to take this one.
That's a really great question. First of all, yes, their tribunal secretaries do have to make disclosures when appropriate. And I would encourage anyone seeking a tribunal secretary appointment to review the IBA guidelines on conflicts of interest. So there, they set out different kinds of situations in which both arbitrators and tribunal secretaries might face conflicts of interest. So things from having a relative who is on the counsel team to having a financial interest in one of the parties. And so it's very important for you to be aware of what comes under the green list, what comes under the orange list, what comes under the red waivable list, and what comes under the red non-waivable list. And there are certain steps that you should take depending on what list your conflict of interest is under or potentially under. It's very important to make a disclosure prior to being appointed. And even if you're not sure, I would say that it's worth erring on the side of caution and still making a disclosure.
Thank you. There are two related questions, and maybe I'll pose this to Juan. Well, that's kind of similar or the same question. It says, is being tribunal secretary a stepping stone to becoming an arbitrator subsequently? And I assume another attendee has asked, when is a good time to transit to taking on arbitrator roles? How many years? You know, I don't know if you want to elaborate on this a little bit.
Sure.
Yeah.
Well, I think to some extent, Ole has just touched upon this question before. I think it's a great learning experience, and the skills that you get are very useful for becoming an arbitrator. I know from a fact that many institutions value the tribunal secretary experience when they are searching for candidates to get their first appointments. But to be honest, it's difficult. I cannot tell you, okay, do it for 3 years and then you will have many appointments just like coming your way, and you will need to say no, thank you, I'm full. I think we would all love for it to be the case, but I mean it's simply not the case. When to transition, I think to some extent it's a matter of luck. Once you have put all of the work into being able to transition, if you're not ready to become an arbitrator and you have not put the hours and you don't have the skills, then this will never happen. But even if you do this super fast, then there's always just a tiny bit of luck into it, that they were seeking for a candidate in an institution that knows you with the language skills that you have, so on and so forth. I would say also it depends on the legal culture of the country. Perhaps in Colombia, it is in domestic arbitration in Colombia, it's not uncommon for people to be very senior and still act as tribunal secretary. Very senior, I mean, sometimes the parties are thinking about appointing an arbitrator. That person is not ultimately appointed, and the tribunal appoints that person as tribunal secretary. So it's that same level of seniority of an arbitrator, but I think we're quite unique in Colombia about this, and this also reflects in the fees of the tribunal secretary. In Colombia, you will get 50% of the fees of an arbitrator, which I guess we can all say that's a lot. That's quite substantive.
Thank you. We're obviously 2 minutes over, so I'm going to end with 2 questions. I'm going to pose both of them to Ole. So one of the questions is, can an in-house counsel work as tribunal secretary? Are there any conflict issues? And the second one, which is unrelated, but I'm going to ask you anyway, if you can, Tariq asks what steps can be taken to generate awareness about the role of tribunal secretary so that arbitrators start including tribunal secretaries in arbitrations. Obviously, it's not the case that tribunal secretaries are commonly used across the world. I see one of the questions was something about, does an Indian ecosystem encourage tribunal secretaries? I'd say it's very rare currently in India, at least for domestic arbitration. So maybe you can take the in-house question, and then how can we generate awareness? And then I'm going to thank everybody and wrap up.
Sounds good. So on the in-house question, I've never seen it, but I don't see why it wouldn't be possible. We have in-house counsel acting as arbitrator from time to time in totally unrelated cases, obviously. And so I don't see why, if that in-house counsel knew, an arbitrator who might be interested in hiring them as a secretary, couldn't do it for ethical conflict or whatever reasons, as a general matter, right? Obviously, if there are specific issues, you would look at them. But I don't think in-house counsel are barred per se from acting as secretary. And that maybe also, just to briefly answer another question that you didn't pose, but I saw in the chat, you also don't necessarily need to be a lawyer, although I think that's a lot more difficult. Someone asked, if you have great project management skills and speak the language and so on. I would say yes, some of the tasks you can do, right? You can book hotels, do the finances and so on. That's something that secretaries sometimes do. But then again, equally obviously, it's difficult to get involved in legal work if you don't have legal training. So I think that's a bigger hurdle than the in-house counsel one. What do we do to, advertise the role of tribunal secretaries, in particular to arbitrators, to make sure secretaries get appointed more often and also get appointed more often formally? Well, we do this, what we're doing right now. And I think that's important. Obviously, our audience is maybe not made up of 66 arbitrators, but still, I think it's important to show that people who carry out the role of the secretary are confident about it and show their faces. So I think that's a good first step. The institutions help as well, because they more or less make it mandatory now for secretaries to be appointed formally if there is a secretary. But I think we still have a long way to go. Shanelle, you mentioned that maybe a geographical factor, and I think that's true. But it's also still a cultural factor. And I think a very good example is the LCIA. Since 2020, they have regulated in their rules the secretary position, also requesting that the tribunal get the parties' consent and show them the secretary's CV and so on. But if you then look at the annual statistics of the LCAA, you see that, I forget the exact numbers, but something around 10% of cases only a secretary gets formally appointed. So in 90% of LCAA cases, there is no secretary that would be known to the parties, or the LCAA for that matter. And I think we can all agree that it's unlikely, Juan, I think, mentioned at the beginning, very unlikely that there are 90% of LCA cases where no one helps the tribunal and there's no one behind the scenes to assist in all of these things we discussed. So yeah, here's a call to arms to everyone out there to advertise the position and to make sure it's promoted also vis-a-vis more senior lawyers, because I think it is extremely valuable for young practitioners. And there's really no harm in it if it's done right. That means if the parties know what the tribunal intends to do with the secretary.
Thank you so much. I learned a lot about tribunal secretaries today, as I hope that the audience did too. I'm going to wrap up by thanking our panelists, Sunita, Juan, Simona, Ole. And again, thank you to the IAMC and Singapore Very Young Arbitration Practitioners for organizing this. And thank you, Sunita, specifically for organizing this. We hope that you have learned something, that was an enriching conversation. There were some practical tips that hopefully you can take back, to your tribunal secretary work, and hopefully you can find tribunal secretary work based on some of the tips that the panelists have given. But all in all, otherwise, hope you have a great rest of the day. And thank you very much for taking the time to attend.